Judge, I'm off the phone. Because I got so much time to make that point. I'm gonna do that, you know. I'm happy with that, you know. You shouldn't lose. So, quick slate project. So we gotta come in and say,
Saturday.
yeah, my clean slate project.
What's that?
But the governor automatically responds. Now we have to update our system.
Rotate.
Basically, they don't know what to do. Basically, because they don't know what to do. It's a real, that be real careful and dictate.
Listen.
Yeah, so what happened, I didn't want to talk too much about that. It's very important. Can you hear me okay? Yeah, I suspect, we look for the start of the engagement. I was aware of it, all 2 years ago, like, you know, you know, you might some of the things I did was that. So if they want to have this, but we can't do it. No matter what program you program, plus support program. When you're away for a while, of course, start out with engagement, see what that goes. You know, the goal is to get you back there. It's not an engagement. Probably around 40 days. You know, we get this management, you know, we need so much practice to do it. And then, having people mind the needs, that did help. That did do it. Someone else, maybe someone else can do it. That's a mindset. But I think we try it out, do it. Give it the best shot. Demonstrate you don't need to be there. And how you demonstrate that is by doing everything I tell you. So you know, take time one, get out, we can do it. And there is no accountability, you're not walking away. When you accountability, you're going to get frustrated with yourself on the program. You're willing to keep that. Yeah. That's what we go to the problem is that our partner is But I'll tell you what, you demonstrate innovation that you do, and you just get it done. That will be the thing. Secondly, so because you move there and do that. And so the quicker you demonstrate that, and you know, this, like I tell people, this, you're a public not now, you're raise it. Because turn it against it and always do just keep staying there all the way. So I know it's good. I know that's right now, just give it to them if you can. And I don't do it now. Yeah. And then, you know, I hear you thought about that before you do it. And it's really, you'll get there. There, we can eat this and do all of this, do it, and get them to appreciate that. And they will. There's really not something to do, no time, and so on. You can't do it, time to do it, and do it. Because we don't reset what we say, we not for that, we are much more which I hope that you want to do. I'll see, I hope that, I mean, now you do that, so we need to know, we get up and put that and we put it up. No. No.
Morning.
How do you?
That's okay, if you want to listen, I'm gonna have someone connected because they wasn't connected to the audio, so when you're ready to call the page.
Okay.
Yeah, it's still ready to get it ready.
is so, my hair is not working, so we gonna be doing this, you know. Let's do it. If you want to invest in that, there is no rule. But I have to be attorney. Make sure that here is in the record.
But it was good, and I do recommend it for, I know what you.
Thank you, Mr. Reed, the motion is read with Mr. Whiten.
Thank you, good morning, Your Honor, legislative team.
And your motion is read. Meaning, I do see you on the
Your Honor, legal matters, case management for special support.
what I can notice here. We are going to get started with here. I had a few check meetings on this morning, is that correct?
Yes, Your Honor, we have, sorry. Here as well as, Robert Britton, and then I know I also have, his fellow because he's not on yet, since it was a week 45, so hopefully we'll see.
All right, so let's do the check in. Let's go. People, you don't know about. We know, you know what, Mr. King, the full name of the
I'm good, all right,
Thank you, very well, thank you. I like Mr. Taylor, I need to check in on you. You'll make sure that everybody is engaged into everything.
Thank you, Don.
All of you, make it very good. You follow through.
Yes, I am. And I have to.
Yeah.
Well, yeah.
Go ahead, you want to say something?
Say, 2, 3, 1,
All right. We're here with Mr. Taylor. We are returning to that. I have 80. We will have to wait a minute. We are going to have
birthday.
Whoa.
Good morning, everyone.
Morning.
Good morning, Judge.
Good morning.
Okay, first up, I have Mr. Sinclair. Mr. Sinclair, you're here on red.
Yes, sir.
We're ready on red.
Calling case number 2305-800201, people of the state of Michigan versus Nino Red. Defendant is charged in count 1, homicide, murder, first degree, premeditated. Count 2, weapons, firearm, possession by felon. Count 3 and 4, weapons, felony, firearm. Defendant has a habitual offender, second offense notice.
Appearances for the record, please.
Morning, Your Honor. My name is James Kehoe and my P number is 82812 on behalf of the people.
And good morning, Judge. I'm Christopher Sinclair, P80512, appearing on behalf of Mr. Red, but I don't see him on the screen right now.
Did you want to wait on him or waive his presence?
He wanted me to address bond, and I wanted him to be here for that.
And I'll come back to you then. Mr. Schwab, good morning.
Good morning, Judge. How are you?
Good, sir. You here on Whitfield?
I am. I don't see him being present.
Did you want to wait on him or waive his presence?
I'm sorry, Judge?
Did you want to wait on him or waive his presence?
Well, I could waive his presence, but I must honestly say I have had no contact with him. His phone number is out. I'm going to try to get to him. If the court would let me, I'd like to set it for an exam.
Okay, let's call.
Calling case number 2305-810601, people of the state of Michigan versus Marquay Whitfield. Defendant is charged in count 1, assault with a dangerous weapon, count 2, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Your Honor. For the record, James Schloff on behalf of Mr. Whitfield.
What's your pleasure, Mr. Schwab?
If I may, I'd like to set it for an exam.
You waiving your client's appearance for purposes of this hearing?
I will.
Court will waive the defendant's presence, continue to plead not guilty and set this matter for preliminary examination. How is August 7th at 11:15?
Did you say the 7th?
Yes, sir.
Okay. And what time did you say, Judge? I'm sorry.
11:15.
That'll be fine.
Fine, we continue. Thank you. Okay, Ms. Phelps, good morning. Ms. Phelps,
Good morning, Judge. Sorry, I was having trouble finding the mute button.
Here on
I'm
Matthew.
here on, yes.
Okay.
And he's in custody, so I will wait for him.
You're gonna wait on him?
Yes, Judge, we have a special prosecutor, Elizabeth Moore, also. I'll text her
Moore.
and find out where she's at.
Ms. Moore is in the courtroom.
Oh, she is? Awesome. Okay.
But you wanna wait on your client, right?
Yes, Judge.
Mr. Jersey.
Good morning, Your Honor. Robert, I'm here on Deontay Braxton and also on Fred.
Braxton and Barnett.
They're both in the jail.
You wanna wait on them or waive their presence?
Thought I saw Mr. Braxton on the arrays a couple minutes ago.
Mr. Braxton is here. What about Barnett? You wanna wait or?
Well, I suppose, yeah, right after.
I can't understand what you're saying, sir.
Yeah, we can. I don't know if you want to.
You're still fading in and out.
Can you hear me now?
Yes. Yes, I can hear you.
Okay, so we can go ahead on Braxton.
Calling case number 2305-810501. People of the state of Michigan versus Keontae Braxton. Defendant is charged in count 1, assault with intent to do grave bodily harm less than murder by strangulation. Count 2, assault with a dangerous weapon. Count 3, domestic violence. Defendant has a habitual offender for defense notice.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Robert for Mr. Braxton, P number 33195.
That works, Your Honor. He is.
Mr. Braxton, tell us your name for the record. What's your name, sir?
Deontay Braxton.
What's your pleasure, Mr. Jersey?
I cannot hear you.
Set it for
I believe you said for exam. The court will continue to plead guilty and set this matter for preliminary examination on House August 9th at 10:30.
9 to 10:30 is fine, Your Honor.
Bond will be continued. Thank you.
That's reduction of bond. He's
Sir, I don't think your plugs are working because I can't hear you. I see your mouth is moving, but nothing's coming out.
let me see if I'm muted. I don't.
Now I'm getting about every other word. It's not working out, Mr. Jersey.
Okay, well, I'm across the street. It's kind of odd that it would be hard to check, but reduction of bond, either a person or things.
Not understanding you, sir. Sorry.
Can you hear me now?
Barely.
Yeah.
Why don't you try it without the earplug, sir?
Without the earphone.
Unplug.
How's that? Is that better?
Much better. Now, what were you saying?
We're going to ask for a reduction in bond, or either a personal bond or a 10% bond. He's in the jail. He can stay with his mother in Pontiac, and also he's consent to a GPS tether.
Okay, so why would I do that?
Pardon?
Why would I do that?
Because he's not a flight risk. He'd be away from the complaining witness. He's got two small children that he needs to support. He runs his own business.
Is he supporting those children now?
Yes.
How?
Well, now not that he's in jail, but he has his own. It's a repair business, repairs houses, repairs cars.
You pay child support, Mr. Braxton?
And he pays child support. Actually, the children he was living with the children and the mother, but that's where he'd be agreeable to vacate the premises and stay away.
Mr. Braxton, you pay child support?
Yes,
How much do you pay in child support?
it's $100 a month.
$100 a month?
Yeah,
How many kids? How many kids?
2.
How are they gonna live on $100 a month?
That's what the judge I gave ordered me to pay.
I'm sure they're not missing your little $100 a month. Where do you work?
Can't hear you.
Where do you work?
I own a construction business. It's called KJB Home Repairs, and I work for a
Your
plumber.
construction business and all you're paying is $100 a month. Why is that?
No, I just started the business in 2020. And I was on, they put me on child support, and
2 years ago. Why are you just paying $100 a month?
that's what the judge ordered me to pay.
How are your kids surviving off $100 a month?
I mean, I do more than just that. I just pay the court the $100. I take care of them off the side.
People,
Your Honor, at this time, I'm going to ask for no reduction in bond. The allegation is that he put a knife to the complainant's throat and he strangled her until she lost consciousness. So at this time, I'm going to ask for no reduction.
what's his current bond? What's his bond? His bond is presently set at 40,000 cash surety with the GPS tug.
You know, I have my personal issues.
How much can you afford to post to get out, sir?
Nothing right now. I don't have nothing to post right now.
But you own a construction business.
There's no money saved up.
I'm sorry?
I said I have no money saved up now. It was just basically bills and taking care of my kids at that time when I was out. Yeah. Yes, you do.
All right, what I'm gonna do is I'm gonna refer it to pretrial services for final recommendation and see what they have to say. Do it again if necessary at preliminary examination or after the preliminary examination.
Thank you, Judge.
Okay, thank you, Your Honor.
Okay.
We
Are you ready on Barnett, sir?
Yes.
What do you want to do with Barnett? You want to wait on him? Wait, Mr.
He
President.
has, he was referred to the forensic center for competency. They've opined that he's not competent, but restorable. And they said that they waitlist him for a bed for a hospital.
Okay, let me call the case.
Calling case number 2206-009701. People of the state of Michigan versus Frederick Barnett. Defendant is charged in count 1, criminal sexual conduct, 4th degree. Defendant has a habitual offender, 4th offense notice.
Appearances for the record, please.
Good morning, Your Honor. Elizabeth Moore on behalf of the people, P84724.
And Robert Jurzik, P33195 on behalf of Mr. Frederick Barnett.
And what's your pleasure, counsel?
There was he was referred to the forensic center. They said he's incompetent, but restorable, and they could waitlist him for a bed.
All right.
Mr. Honor, people stipulate to the report and request that he get further treatment this time.
Okay. Court will re-refer him for treatment. And we'll set a review date for. We'll set a review date for November 3rd at 8:30.
November 3rd at 8:30. Let's see. Got November. Is that a Friday?
Yes, sir.
That's fine.
All right. Bottom, we continue. Thank you.
Thank you.
Thank you, Judge.
Good morning, Ms. Silver.
Good morning.
What can I do for you?
I have Jesse Mabin, don't I?
Okay.
Do I? Is that in here?
Yes, it is.
Oh, good. I'm in the right place. My prosecutor's Miss Rozak.
And I'm going to be standing in for her today.
Oh, okay, perfect. We're ready.
All right.
Calling case number 2305-799001. People of the state of Michigan versus Jesse Navy. Defendant is charged in count 1, assault with intent to murder. Count 2, robbery armed. Count 3, assault with intent to do great bodily harm, less than strangulation. Defendant has a habitual offender, 4th offense notice.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249, standing in for the Assistant Prosecuting Attorney, Elena Rozek.
And good morning, Your Honor. Gabi Silver appearing on behalf of Jesse Mabin. He is in the jail. I'm not sure that either of those two gentlemen are Mr. Mabin.
Sir, are you Mr. Mabin? Wayne County Jail? What's your name, sir? I can't hear you.
Your Honor, Mabin is not on the screen. Matthew.
Yeah, that's not, neither of those are him, Judge.
Okay, what's your name, sir?
Matthews. This is Taiwan Matthew.
Okay. All right.
Do they have Mr. Mabin handy? I mean, I am going to request competency, but based on his extreme paranoia and being out of touch with reality, I'd like him to hear what's happening. Whether he processes it or not is another issue. So if he's readily available, I would ask that he be brought to the screen before we do my case.
Wayne County Jail, do we have a Mr. Mabin available?
And we require a sergeant to remove him from his cell.
Yeah, see what I mean? Well, so is he saying they're not able to do that? I guess is what I'm trying to find out here.
He said it required a sergeant to remove.
Do they not have a sergeant able to do that?
Currently, we don't have one available to transport him.
When you come back.
Okay, I would waive his presence then.
The court will waive the defendant's presence. We'll refer him for a competency evaluation. Due date for November 3rd at 8:30.
Okay, thank you, Judge.
Thank you. Have a good day.
You too. Bye.
Thank you.
Bye, Mr.
All right, Ms. Phelps.
Bye-bye.
Ms. Phelps, are you still here? Mr. Washington, good morning.
Good morning, Your Honor.
Who did you have?
Yeah, I have Kevin Quilter. I do see him on the Zoom.
You do?
I thought I did. Let's see.
Okay, yes, he's here.
Okay.
Ready on.
Calling case number 23058101001, people of the state of Michigan versus Kevin Yvonne Quilter. Defendant is charged in count 1, assault with a dangerous weapon, count 2, weapon discovery firearm, count 3, domestic violence.
Excuse me. Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Earl Washington, Neighborhood Defender Service, P31383, on behalf of Mr. Kevin Quilter.
Tell us your name, sir.
Yvonne Quilter.
What's your pleasure, Mr. Washington?
Judge, we're requesting a preliminary examination date.
Out August 9th at 9 o'clock.
Yeah, that would be good, Your Honor.
Okay,
And Your
August
Honor,
9th.
may I speak to Mr. Quilter in a breakout? I need to get his contact number.
Go ahead and join the breakout room.
Okay.
Wayne County Jail, do you have a Mr. Red available for me? Mr. Braxton, you're all set, sir.
No, Your Honor, Mr. Red is over at the jail. They haven't come on yet.
Okay. You have a Mr. Red for me, sir?
We're good with Mr. Braxton?
Yeah, we're done with Mr. Braxton. Do you have a Mr. Red?
I believe he should be logging in from another computer.
Okay.
Should be Division 2. Thank you, Your Honor. Have a blessed day.
Thank you, you as well. Mr. Matthews, I'm not sure where your attorney went, but she was here.
Excuse me.
Yes, sir.
Um, I was talking to the attorney. I left the breakout room. I wanted to know if I was okay to go for this meeting.
Yes, sir. We'll see you on August 9th at 9 o'clock in person in 36th District Court.
Okay.
Have a good day.
Set August 9th at 9 o'clock.
Yes, sir.
Okay, thank you.
Okay, Mr. Matthews, here's your attorney. Ms. Phelps, Mr. Matthews is here now.
Great. Thank you, Judge.
She was in the court. Well, here she comes.
Calling case number 2305-64300 versus Taiwan Matthews. Defendant was charged in count 1, criminal sexual conduct, 4th degree, count 2, criminal sexual conduct, 4th degree, count 3, aggravated indecent exposure.
Appearances for the record, please.
Good morning, Your Honor. Elizabeth Moore on behalf of the people, P84724.
And good morning, Your Honor. Neighborhood Defender Service of Detroit by Natalie Phelps, P83355, appearing on behalf of Mr. Matthews, who's also present via Zoom. Mr. Matthews, can you please state your name for the record?
My name is Taiwan Matthews.
What's your pleasure, Ms. Phelps?
Judge, I am in receipt of the competency report from the Forensic Center. I would ask that you adopt the findings in the report. And then if we could address bond again, I guess.
Ms. Moore?
Your Honor, I also ask that you adopt the findings in the report, or I stipulate to the report.
All right, the court will make a finding that the defendant is not yet competent to stand trial at the court, but he is restorable, so the court will refer him for further treatment. We'll set a review date for November 3rd, 2023 at 8:30.
Thank you, Judge. And if I could just briefly renew my motion to reduce bond in this case. We did have a hearing on this a few weeks ago where the social worker from my office presented a report to the court and indicated that we would be able to get housing for Mr. Matthews at Team Jefferson. I think the concern of the court and the prosecution was Mr. Matthews' ability. It's not a secure facility, but if he was on tether, the Team Jefferson is very experienced with people in this situation. And if he did try to leave or take his tether off, obviously they have staff there who monitors their patients and would call the police immediately if something like that were to happen. So I would just ask that, considering that additional information, if the court would consider reducing Mr. Matthews' bond while he's waiting for placement for treatment.
What circumstances have changed since our last hearing?
Judges, it was just that additional information about the staff there that I think we didn't bring to your attention at the last hearing. And so I just wanted to present that additional.
But you did.
I'm sorry?
Almost certain that you did bring that to my attention the last time.
Oh, okay. I thought that I omitted that. So that's all the additional information, Judge.
Pretty sure that you did. And since no circumstances have changed, I'm not inclined to change the bond either. Bond will be continued. Thank you.
Thank you, Judge.
Thank you, Judge.
Mr. Matthews, you're all set. Okay, me and Tom will come and talk to you soon.
Okay.
Yes.
They bring it red on. It's competency.
Judge, I was in a different Zoom meeting, so I don't know if you called my name or not.
No, we're still waiting on your client.
Okay. I don't have an objection to setting this matter over a week if the court is okay with that, because there's some discovery issues that Mr. Kehoe and I are trying to address. Like I said, if that's okay with the court.
No, sir.
Okay.
We're going to get your discovery issues resolved today and set an exam date today, if that's what your pleasure is.
Yeah, so we definitely want to set an exam date. It's some one part of the discovery issue is like a tech issue. Like 5 out of the 20 files that I received weren't working properly, and then the other one requires some level of investigation. I don't know exactly how long it'll take to resolve it, but it's like a video issue of like.
I'm sorry, what were you asking?
I was just explaining to the court just what the tech issues were.
Okay. But you wanted to wait on your client, you don't want to wait in his presence, right?
If he's not available at this point, I guess we could move forward.
We just got a call from the county jail saying they were about to bring him on, but I haven't seen him yet.
Okay. Okay. I prefer to wait for him, but I guess if he's not here in 10 minutes, yeah, we'll just move forward.
Okay.
Thank you.
Judge King.
Okay, Mr. Sinclair, I think we might be in business.
Yes, sure.
Yeah, Mr. Red?
Yes, that's him.
Okay, we're ready on red.
Calling case number 2-0-201, people of the state of Michigan versus Nino Rick. It's charged in count 1, homicide, murder, first degree premeditated. Count 2, weapons, firearm possession by felon. Count 3 and 4, weapons, felony, firearm. Defendant has a habitual offender, second offense notice.
Appearances for the record, please.
Morning, Your Honor. My name is James Kehoe and my P number is 82812 on behalf of the people.
And good morning, Judge. I'm Christopher Sinclair, P 80512, appearing with and on behalf of Mr. Red, who's present on the screen, and we consent to proceeding via Zoom.
Tell me your name, Mr. Red.
Nino Giselle Wesley Red.
All right, what's your pleasure, Mr. Sinclair?
Yes, sir. So today's the day and time set for probable cause conference. We're going to demand a preliminary examination and like to address bond when the court is ready.
All right, the court will continue the plea of not guilty and set this matter for preliminary examination. Out is August 10th at 10 o'clock.
Judge, so there are some outstanding discovery issues on the file. Mr. Kehoe and I have been in communication. I received approximately maybe 20 files yesterday. 15 of them appear to be working fine, but there are issues with 5 others that I'm not able to open the files. And there's an issue with a ring video that only shows, a few seconds of the incident that occurred that has caused Mr. Red to be in custody. My position is the video could be exculpatory, and I think it's important to have it in place for the preliminary examination. So I'm just asking for a date that's a bit further out. I'm sorry, I can't hear you.
Can't we just resolve those discovery issues today?
So Judge, we started the conversations on it, but I'm not sure that the resolution of those issues can be reached today necessarily, but Mr. Kehoe will be in a better position to speak to that.
So Judge, as far as the ring video, Mr. Sinclair and I confirmed that he has the same amount of ring video that I have. Whether or not there's additional ring footage, I cannot say at this time, but that's one of the few issues that have been brought to my attention that I'm working with the Detroit police to make sure that we have at least all of that pertinent information, because it could be important for the exam. That said, Judge, I'm going to be speaking to the OIC again today about the outstanding items that we've requested.
August 22nd. Time 10 and 1:30.
Your Honor, I do start a jury trial the 21st, and at this point it is going.
How many witnesses do you have on this, Mr. Kehoe?
On this file, Judge?
Yes, sir.
I would say no more than 4 based on the reports I have at the moment, Judge.
Okay, how about August 15th at 11:30?
That day is free for me, Judge.
I'll be in a homicide trial on the 15th. That starts the day before on the 14th.
Well, it looks like we're gonna have to make 10 work. I have the 10 o'clock spot available as well as actually, that's it, just 10 o'clock. August 10th at 10 o'clock.
I mean, if that's what we have to do at the moment, I guess that's what we have to do. And I'll provide updates to court as it relates to the outstanding discovery issues and whether or not I believe is important to have it for the exam.
And as for the 10th at 10, Your Honor, that's a good date and time for me.
Okay, August 10th at 10 o'clock, Bond, you want to address Bond, Mr. Sinclair?
Yes, sir. Mr. Red is 30 years old. He has 5 children. He owns a catering company. As far as education, he has a GED. This is a homicide case, but based on the discovery that I have received and read so far, there is an identification issue in the case. There are no witnesses that say that Mr. Red is responsible. And there is no lineup of any witness pointing out Mr. Red as the person who's responsible for the death of the individual in this case. So of course that leads me to believe that the likelihood of conviction is low without that information. So I'm just asking the court for a low cash bond in this matter.
Mr. Kehoe?
The allegations in this case are going to be that the victim and an individual he was walking with were walking down the street approximately 2 in the morning when a vehicle driven by Mr. Red approaches. He gets out of the vehicle, some sort of discussion or confrontation ensues, and then Mr. Red shoots and kills the victim before driving away. The firearm has been recovered in this case, and preliminary matching ballistics have match the casings to the gun, so the identification isn't really in genuine dispute in this case, Judge, as well as the fact that the defendant has been previously convicted of armed robbery out of Oakland County. So this is an individual that has prior experience with the criminal justice system, Judge, has been shown to be a violent person. I ask that you do not change the bond at this point, but if the court is inclined, I do ask that you order a DSU instead.
Where was the gun allegedly recovered from?
At the residence, Judge.
It was not at Mr. Red's residence. It was at a location that Mr. Red he was physically present at the location when a search warrant was executed. There wasn't a residence that was in Mr. Red's name. And
it's his girlfriend's residence, Judge.
Wow, what a coincidence.
And Mr. Red has not been identified as the driver of the vehicle, and there was another individual in the vehicle as well. Pursuant to
the other individual was identified as a woman, and the woman was not identified as the shooter, Judge. So I mean, we can talk about this, but I think it's just going to be a matter for an issue at the exam, Judge.
There's no identification. That's the issue. Those are the key words. Has not been identified as. There is no identification.
I'll be continued. Thank you.
Thank you, Judge.
You're all set, Mr. Red.
Thank you.
Okay. You should have given. Should have given.
Hello?
Yes, sir. Why are you back?
I was calling about my well, not my probation officer, but my tether officer asked me to ask about the conditions of my tether.
Talk to your attorney, sir.
Okay. Who's my attorney again?
Did you talk to him, Mr. Washington?
Yes, yes.
Didn't I put you in a breakout room with him?
Yes, he was
You
supposed to
exchanged
contact.
numbers?
Yeah, we exchanged. Well, he took down my number, but he never contacted me.
Okay, he will.
Okay.
All right. Everybody say something smart. You have anybody here yet? Everybody except the defense attorney. Sure. What are we doing today? How are you? Doing well, Judge. Yeah. You came with the crew today? Yeah, more people than I was expecting. Life is full of surprises. Are we ready on Gilmore? Yeah. Yes, sir. Calling case 23576-41, people of the state of Michigan versus Leslie Jose Gilmore. Finished charged in count 1 homicide, murder, first degree premeditated. Count 2 weapons, firearms, possession by felon. Count 3 and 4 felony firearms. It has an additional 4th offense. Appearances are granted.
Good morning, and may it please this honorable court, P. Jonathan Hicks, appearing on behalf of people, P. 8528.
Good morning, Your Honor. Mrs. Brother, P5, appearing on behalf of Mr. Gilmore, is present.
And Kerry Martin, P8452 as co-counsel. Second chair.
Tell me your name for the record, sir.
Leslie Jose Gilmore.
There's date, time set for preliminary examination. Are we ready to proceed?
Judge, I do have witnesses here. I am ready to proceed, but there was an issue with discovery, and I believe there may be an adjournment request. I'm not objecting to it. I believe there's good cause for it. I provide some further explanation. There's a significant amount of body cam footage, dash cam footage, in-car video that was not made available to me until yesterday. I received it yesterday, attempted to download it. I discovered there are approximately 117 video files. It basically took me all day to get that uploaded. I still haven't had a chance to quality check it to make sure that all those files were correctly uploaded. Once that's done, I can turn that over to defense counsel. But at this time, they don't have access to that. Those 117 videos. I do believe it's true that there will be statements on some of the body cam from the key witness that is going to be testifying on behalf of the prosecution that will not be consistent with this testimony. So I do think it's important that the defense counsel has that information. I did make best efforts to provide it, but unfortunately, that was not successful.
In addition, there are,
Can you sketch the microphone, please?
I'm sorry. In addition, there are 2 videos of the statement given by their key witness where there is no audio whatsoever. We can see the video, but we cannot hear anything. So we're working to resolve that issue too. So, consistent with counsel's representations, we do not feel proper to proceed without having had an opportunity to review all the discovery videos, and especially in light of the nature of the case. One more thing. Unfortunately, we discovered during what we, as regards to the discovery that we did proceed, and that was that the decedent had, at the time of this death, pending case, for much the same behavior that is alleged in the case. We asked that the prosecution should provide us with the discovery on that for our purposes of review. Counsels indicated that we would object as to relevance. We would still pursue that information and ask the court to allow us to discover that.
How is it relevant?
Well, it would be relevant to determine whether or not there was a potential self-defense. It would be relevant as to whether or not my client was reacting to.
It would only be relevant if your client knew of such a case.
They lived together, so I may be misunderstood your question.
That doesn't mean anything because they live together. I said you have to know about this case, this aggression that you're talking about.
Without attempting to glean my client's mind, my client didn't know about the case. My client had concerns about the decedent's prior aggressive behaviors. This is not the first negative interaction as between the parties. So my client was in fact aware of the case. In fact, he mentioned it to me, and I reviewed the discovery only to know that it was actually there highlighted. It's a 23 case brought by the people in April 8th or 9th of this year.
So what additional information are you looking for? It sounds like you have.
What I have is just the case number and the fact that there is a case. I do not have any information as to when, why, and how. I would look for discovery provided by the prosecution to that concern.
Mr. Hicks?
Judge, as counsel correctly stated, I don't believe that information is relevant as the court has articulated. I think you're correct that it's only relevant to the extent the defendant knew about it. So the actual substance of the discovery packet, other unrelated case, is not relevant to these proceedings. That said, I am looking into whether or not I can provide that. I just haven't had a chance to have the discussion with the appropriate parties in the office because although I don't believe it's relevant and I don't believe it's a required disclosure of the Brady, Giglio, or any of the court rules, I'm willing to provide it out of the interest of cooperation if there's no policy in my office that I'm not aware of and I can't provide discovery regarding another case.
So how do you intend to get this information for the court?
Well, if I have a viable self-defense, then I would get it in for my client.
Your client's not testify exactly.
No, but I still would like to preserve the record as to my discovery request as now that you know we have.
Discovery is on one, that's not something that we need an exam, is what you're telling me.
No, I may not need an exam, but my point is to, as early as possible, make the court aware of my interests, concerns, and lack of information.
The record has been preserved, and should this case make the circuit court, because the study is ongoing, bring that up to the circuit court.
Will do. Thank you so much. Oh, Your Honor, there is a question mark number. This 572.
many witnesses are you calling?
Probably two, but maybe a third, depending on how many witnesses specified.
How is August 17th at 10 o'clock?
It's Herbie Restaurant.
Oh, I'm sorry, it's not. August 17th. Let's work it out. I can do August 15th at 11:30.
Got an exam for you that morning, Judge, so yeah, let's just.
Okay. August 15th at 11:30. Court finds good cause for the adjournment.
Thank you very much. Thank you, Judge. Judge,
Okay, sir.
I'm sorry, if I could just make one request that the witnesses be brought into the courtroom that did show up for this meeting today, which be instructed by the court of that next. James, give an obligation.
Go ahead, have a second. One in. Good morning. Please step to the podium and tell me your name. Alonda.
Yolanda.
Yolanda. What's your last name?
Huh?
What's your last name?
Ruffin.
Ruffin.
Yes.
Yolanda Ruffin. Good morning, Ms. Ruffin. Thank you so much for being timely here today. Sometimes things like this are beyond our control. Unfortunately, I have to adjourn today's preliminary examination scheduled for today. We are adjourning to August 15th at 11:30. Is that a good date and time for you?
Yes.
Okay, so I'm ordering you to be back on that date and time. Regardless of whether or not you receive a subpoena, I'm ordering you to be back. To be back. Let's get you there a little before these things happen. I don't want you to be late, okay?
Okay.
We're going to resolve this matter, at least at this stage of the proceedings on that day, this time, that time, okay?
Okay.
Thank you so much. Sir, please step forward and tell me your name. James Jackson. James Jackson. Mr. Jackson, thank you so much for being timely as well. Again, things like this are beyond our control. The adjournment has to be right. And that is in fact the case today. But I order you to be back on August 15th at 11:30 so that we can resolve it at this stage of the proceedings. Okay, is that a good date time for you as well? Yeah. Okay, we'll see you back August 15th. Probably before a little bit before that, so that you're on time, okay? And I'm ordering you to be back on that date and time, okay? Thank you so much. Have a good day. Sorry for any inconvenience, but those are the only two mistakes?
Yes, Your Honor.
Okay. All right. Thank you. Anything else?
No, yeah.
Okay, guys, have a good day. Thanks. All my food is not this for today. Hope to see you tomorrow, same bat station, same bat time. Have a good day, guys.
I understand why you want to look at it.
Jeff?
Judge King?
Yes.
How you doing?
I'm good. How about yourself?
Great.
Great to see you in a while, man. Where you been?
I've been laying low, preparing for this lieutenant rank.
Oh,
Yeah,
congratulations.
so they just
All right.
announced it on Monday, so I should be lieutenant within a month.
Outstanding.
Yeah, so
So, you know, the cream always rises to the top. I'm not surprised.
thank you, sir. I
This is
appreciate it.
just the beginning for you.
Thank you, sir. I
All
appreciate
right.
it.
Okay, you be safe out there.
Yes, sir.
Good job.
Enjoy the rest of your day.
You as well.
Thank you.